Part 2 of torts, and we're now looking at unintentional torts. Difference between intentional and unintentional torts. The intentional tort, the defendant had intent and knew or could foresee their actions could cause harm. For an unintentional tort, and this is called negligence, you're looking at the defendant didn't wish to bring about the consequences, had no intent. Basically, their conduct only created the risk of the consequences, and their conduct was not intentional. So the risk must be foreseeable, and I guess the best way to explain all of this is to kind of give you an example. Let's say you have a retail store, and you own the retail store. You are inviting people into your business, so the store should be safe. There's a reasonable suggestion that everything in the store or the store should be a safe environment. There's a hole in the roof, or there's a leak in the roof, and water drips down into a puddle of water, and you don't get the sign out in time, or you just don't think about it. There was no intent on your part. It's just simply that it was not thought of. So there is a risk there, right? You could foresee that. If you saw that or you thought about it, you would see the risk. So the risk is foreseeable. But you didn't get it done for whatever reason. Somebody comes in and slips on it and falls. That becomes an unintentional tort through your negligence of not taking care of putting a sign down or cleaning up the water or fixing the roof, or however you want to look at it. There has been a cause for injury for somebody. So the injury was foreseeable, but it wasn't intentional. I think that makes sense. Okay? There are 4 proofs that are required, or 4 elements, and they are duty of care, breach of duty, causation, and then damages. There has to be a recognized damage. And let's go back to the storekeeper who has a hole in the roof, who has water on the floor, who didn't put up the signs or fix the roof. They have a duty of care to create a safe environment. They breached that duty by not doing so, which in turn caused somebody to fall and caused the injury, which was, in theory, a recognizable injury, say a broken leg or maybe a broken arm. Unintentional torts can apply to just about all of the other torts, the intentional torts we have, and those intentional torts were assault and battery, false imprisonment, infliction of emotional distress, defamation, invasion of privacy, fraudulent representation, frivolous lawsuits, wrongful interference, and trespassing against property or disparagement of property. Those were our intentional torts. Some of those could become unintentional torts, or could be looked at as unintentional torts. So that kind of sets the stage. A little bit confusing, but let's go back down to the duty and care and its breach. Duty of care and breach. The main thing that you want to realize here, the standard for judging this, is the reasonable person standard. And that says the duty is measured by the standard of reasonableness. If a reasonable person would have done or would have completed the task that caused the injury, then it was negligence. A reasonable person, if they had looked at the puddle of water, either number 1 would have cleaned it up, put a sign up, and eventually would have fixed the roof. the store owner or storekeeper did not act as a reasonable person. So you have a duty as landowners or as a store owner, however you want to look at that, to warn your business invitees, which is a fancy way of saying customers, of the risks. So if there is a puddle of water, you have a responsibility to tell them about that, because that's not normal. That isn't normal to have water puddled on the floor. And obvious risks here, they say, are an exception, unless it's a child, which I have always had a great fear of automatic doors and little children walking around and getting caught in between of them. I think there should probably be more safety precautions on that. So a child doesn't think as an adult, which is obvious. So things that are obvious to us as being risky, children are not aware of. So you have to kind of think of a child as a child in some cases. And then the other one that comes under the duty of care is the duty of professionals. And if you have the knowledge, skill, and intelligence of a professional that many people are not exposed to or not aware of, that becomes your duty. If you don't, how do I want to put that? If you don't make others aware of that, then you are, that would be a breach of care. Well, the causation, I think we pretty well understand that. If there is a breach, it does cause injury. There are two questions the court's going to ask. Causation, in fact, well, and this mainly is, if it wasn't for the breach, would there have been an injury? And that's rather obvious. The other one is called approximate cause, and that's a question not of fact but of law. And is there a strong connection between the breach, the cause, and the injury? Is that very strong? And that will be looked at by the courts. And again, we looked at the foreseeability. And then, of course, you have to have damages, or of course you won't have damages. You want your injury has to be obvious, and it has to have a measurement to it, such as damages. And here we come up with a question. Question: select all that apply. The four elements of negligence are duty of care, breach of duty, proximate cause, causation, reasonableness, or damages. You decide. Now, there are defenses to negligence. There's something called the assumption of risk, and here's a very good example of it. Assumption of risk, if you're going to use that for a defense, requires that the injured person knew of the risk and voluntarily assumed it. Here's a lady who went to a baseball game, was a fan of theirs, and sat very close to, I guess, the pitching mound, or the pitching area, and was hit in the face by a thrown baseball. She sued, and the Mariners argued that she was a Mariners fan and was familiar with the risk of entering the stands, and therefore assumed the risk of her injury. The court dismissed the case. She appealed, and the state appellate court affirmed the case, which means they also agreed. So the thing was, she'd been to ball games before. She was quite aware that a ball could fly into the stands, and she assumed that risk. So nobody was liable for that. There was no liability. Now, the interesting thing would have been, what if a child had been hit by that ball? What would have the verdict been on that? So we'll have to think about that. That's one defense. A superseding case is, well, let's see, an example. I think this may have been in the book. A lady was on a bicycle, got hit by a car, fell down on the sidewalk while she was laying there injured. the house next to her blew up and she was burnt terribly from it, and who was liable for the burns? Well, whoever hit her with a car is not liable for her burns, liable for the injuries she sustained falling off the bicycle or being knocked off the bicycle. But they could not have foreseen the house blowing up, or so that's a superseding cause. And then there are two types of negligence that we need to kind of talk about. There's contributory negligence and comparative negligence. In the case of contributory negligence, if the plaintiff is just a small bit responsible for their injuries, a certain percent is their fault also, then it is thrown out. If the state uses comparative negligence, then the percent of their awareness or the percent of their responsibility for the injury is taken into consideration. I.e., if it was 50% the plaintiff's fault and 50% the defendant's fault, the defendant would only have to pay 50% of the damages. So there's that to always be aware of. And then we have these special negligence doctrines and statutes, and they're kind of interesting. Res ipsa loquaria. There you go. And that's when the thing speaks for itself. It is just an example of this. If a load of bricks falls off the roof of a building being constructed by a company, falls and injures a pedestrian, the company is liable for the pedestrian's injuries, even though nobody saw the load fall and nobody knew who was responsible for it. That is, the thing speaks for itself. It's just obvious. The company is responsible for that. The same thing with train derailments, falling elevators, things of that nature. It just speaks for itself, and the liability lies with whoever had the bricks up there, or whoever owns the elevator or the train that derailed. There's negligence per se, and that occurs, oh my, that's spelled incorrectly, when there's also a criminal statute involved. An example would be a person is injured by a person driving beyond the speed limit. The conduct is automatically considered negligence. You don't have to prove it at that point. It is negligence. That it comes down to how much of the damages is the defendant responsible for. Another one is danger invites rescue, and that's where if you have one party causes injury to another party, and the third party comes along and tries to help the party that's been injured, and they themselves become injured, then party 1 is responsible for party 3's injuries also. Good example is car 1 runs into car 2, pushes him off the road into a ravine. Car 3 comes along and pulls the person out of car 2 to safety. In the process, they break their arm. Car 1 is liable for the medical expense for the broken arm. And danger invites rescue doctrine. We have one called the Good Samaritan statutes, and basically that's if you voluntarily try to help somebody in an emergency situation, they cannot sue you for damages of any sort. Now, what you have to be very, very careful of is different states have different variations of this rule. Here's an example. There's 8 states that provide no immunity to private individuals. 24 states provide immunity to physicians rendering emergency care in a hospital. 6 states exclude rendering emergency care in a hospital. 2 states require a duty to assist if it's a reasonable emergency. Physicians must assist. Indiana law says anyone voluntarily helping in an emergency situation is immune from liability unless there is gross negligence or misconduct involved. So it depends on what state you're in to be aware of that one. And then we have dram shop acts. In a dram shop, you're talking basically a tavern owner or a bartender. They may be liable if somebody becomes intoxicated and drives home and creates an accident or harms themselves in any way. I think this also can come down to social host. Yes, it can. So you have to be very careful, and you have to be responsible for the people who are under your roof at the time. And you have strict liability. And strict liability basically says the liability is there's no fault. It's a no fault. It's a strict liability, and you're responsible. And that usually comes about because of abnormally dangerous activity, i.e., using dynamite, or a dangerous activity because of their extreme risk. Other applications, somebody who keeps dangerous animals, they get loose and they harm somebody. You do not have to show fault at this point. It is a matter of strict liability. Product liability, same thing. So you don't have to show the fault to get the damages or to prove that they were responsible for this. And then we come to cyber torts. And cyber torts are a relatively new developing area, and it's kind of hard to control some of this because it's not all within the U.S. boundaries or our borders. There are some rules out there. Identifying the author of an online defamation. You can actually get a court order to find out where that particular defamation came from, as long as it's within the United States or within a country we have an agreement with. If it's in a country that we don't have an agreement with, or in an area where we don't have control, it's going to be very difficult to get that identification. There is no... they at one time tried to say internet service providers were the same as publishers. And if a publisher published something that was defamation or injurious, they were responsible for it along with the author. That changed in 1996 because internet providers cannot control everything that is put into or onto their internet through their service. So there's the liability for internet service providers, there isn't any. The other thing that's concerning with cyber torts is the spread of spam. Spam is junk mail, email. There's also all kinds of other things floating around out there. The state tries to regulate spam. There's a federal Can Spam Act that also works with pornography. The federal act takes precedent over the state, obviously. And so we go state, we go federal, and there's the U.S. Safe Web Act, which is it's a agreement or between foreign agencies to investigate internet fraud, spamming, and spyware. So if we have an agreement, or if other foreign countries are also a part of this act, then we can go across borders and get some relief or get some support for people who are trying to um, recover damages from cyber torts. Again, this is a new and developing area. It should be exciting to watch. And here's a question. True or false? Strict liability involves dangerous activities. That is the tail end of unintentional. Oops. I'll make you guys sick here watching this. Unintentional torts, or negligence as it's called. Thank you.